being foreclosed on, I mean, they don't sign anything. I mean, if you're doing a title search and you see a foreclosure in it, you see the owners bought the house, mortgage is recorded, next thing you know, somebody else owns the house. Who transferred the title?
In judicial foreclosure states, when there's a sale, the clerk's office transfers title to the bidder at the sale, which is almost always, unless there's any equity in the property, is almost always the foreclosing servicer in Florida. In Florida, typically we see servicers foreclosing in their own names. So when the title transfers, even to make this issue even more confusing, instead of the investor trust transferring, you have the servicer purporting to transfer on behalf of the investor trust through the local clerk's office without any intervening assignments or true transfers being recorded as the headache for the title company down the road. That is, the perfect storm of that is in my Exhibit 1, which is where you have two securitized trusts, both alleging they both own the same note, foreclosing on the same house at the same time. So to add a further layer on this,
two different buyers?
Well, it's an active foreclosure, so it's two different securitized trusts through two different servicers, both alleging in the paperwork they filed with the court, and in one case swore to under Florida's recent civil procedure amendments, alleging they each own the same note and are foreclosing on the same house at the same time. I've also cited to a Florida appellate court decision where one of our appellate courts reversed on the same fact pattern to add another layer to this issue of what exactly the clerk is transferring when the clerk in a judicial foreclosure state actually transfers the title.
Mr. Cox.
Representative Scott, a related problem, and again I have to address some of the testimony from Mr. Deutsch. He described how in some instances MERS will assign a mortgage back out to a foreclosing party other than MERS. I would say in 20 to 30% of the cases that I encounter, when MERS is doing that, and I can give a specific example. We have a case in Maine where a mortgage was granted to MERS as nominee for First National Bank of Arizona. Last year, MERS assigned that mortgage back out to another banking institution as nominee, purporting to act as nominee for First National Bank of Arizona. The OCC had closed that bank a year and a half earlier. MERS had no power to act for that bank at the time that it made that assignment, and it's leaving in its wake a massive title problem all across the country because of this.